You are looking at the exact moment Judge Caldwell appeared to lose patience after what has been described as the leak of a so-called Witness 14 audio, recording earlier this morning, according to multiple reports. The defense team did not simply lose an argument. They became the focus of a rapidly escalating legal crisis. What follows is based on court filings, media reports, and statements from legal analysts. This is not speculation, and it is not rumor, but an account of events as they are being publicly reported at this time. Federal marshals escorted 3 defense attorneys out of the courtroom in handcuffs during an ongoing federal trial. When a sitting federal judge orders officers of the court detained during live proceedings, legal experts agree that an extraordinary situation has occurred. So what triggered this unprecedented courtroom confrontation? According to multiple whistleblower platforms, at approximately 7:47 a.m. Eastern Time, an encrypted audio file labeled W14 Privileged, Do Not Distribute appeared simultaneously on several sites known for hosting leaked legal material. Within roughly 90 minutes, the file had reportedly been downloaded millions of times. By mid-morning, excerpts were being discussed across major news networks. The audio is alleged to feature a recorded conversation involving the prosecution. Protected witness known publicly as Witness 14, along with individuals identified by prosecutors as lead defense attorney Marcus Webb, associate counsel Daniel Harriman. According to prosecutors, one of the most concerning moments occurs approximately 2 minutes into the recording, where a voice alleged to belong to Webb states that the witness should be made to understand that cooperation carries personal consequences. Prosecutors have argued that this comment directly referenced Witness 14's scheduled testimony. Court filings further allege that the conversation includes discussion of sealed grand jury material information that would normally only be accessible to individuals with privileged access. At another point in the recording, the third voice allegedly references the witness's family, including employment and school enrollment matters. Language prosecutors characterize as potentially intimidating. Later in the audio, discussion reportedly turns to financial arrangements. Prosecutors allege that the conversation references payments structured through a consulting LLC designed to avoid direct tracing. Financial records subpoenaed by investigators are said to show wire transfers totaling approximately $847,000 from offshore entities, allegedly linked to individuals associated with the defendant. The dates of those transfers are reported to align with timestamps discussed in the recording. According to federal authorities, the audio has undergone preliminary forensic analysis. Investigators state that voice pattern analysis suggests a high probability match with the individuals identified. Though defense representatives have not conceded authenticity and are expected to challenge admissibility, metadata reportedly indicates the recording was created on January 11, 2026, only days before the courtroom events unfolded. Importantly, prosecutors have emphasized that the recording device was not placed by law enforcement. Instead, filings suggest it may have been recorded by someone within the defense team's broader professional circle. Court documents indicate that a junior paralegal with access to Webb's office may have been cooperating with authorities for several weeks prior to the recording. Former federal prosecutor Amanda Chen told MSNBC that, if proven, the conduct described would represent one of the most serious examples of alleged witness interference she has encountered. Legal analysts reviewing transcripts have noted additional passages in which the speakers allegedly discuss influencing individuals connected to the witness through professional or contractual pressure. In the final portion of the recording, Prosecutors claim the discussion turns to contingency plans should the witness fail to comply. Language they argue suggests a broader pattern rather than an isolated incident. If substantiated, experts say such conduct could expose participants to charges including obstruction of justice, witness tampering, and potentially conspiracy under federal statutes. Some analysts have even raised the possibility of a wider investigation should references to other teams indicate additional coordinated activity. The events in the courtroom reached a climax shortly before 11 a.m. Observers report that Judge Caldwell received a sealed filing from prosecutors and reviewed it silently for over a minute. Moments later, he addressed the courtroom and directed U.S. Marshals to act. According to reporters present, Webb attempted to speak but was ordered to remain silent. Judge Caldwell stated on the record that he had reviewed evidence suggesting criminal conduct by members of the defense team, including obstruction and witness interference. Within minutes, Webb Harriman and junior associate Priya Nakamura were taken into custody. The defendant, real estate developer, and political donor, Victor Ashworth, was left seated alone at the defense table as his legal team was escorted from the courtroom. Legal experts say the implications are enormous. Ashworth's trial has been suspended, and the court is now considering motions related to mistrial, new counsel, and potential privilege issues. Meanwhile, the Department of Justice has reportedly expanded its investigation. Aggressive defense motions to exclude key evidence. Repeated attempts to unmask witness 14's identity. What prosecutors described as a campaign of legal harassment against government witnesses. Everything changed on January 6th, when Judge Caldwell denied the defense's fourth motion to reveal witness 14's identity. In his ruling, he noted increasingly concerning patterns in defense counsel's approach to protected witness issues. According to court documents filed this morning, the FBI had already opened a parallel investigation into the defense team on December 29th, based on a confidential informant's tip. That informant, the junior paralegal mentioned in the recording, had been wearing a wire for 3 weeks. This wasn't about aggressive lawyering. This was about a coordinated criminal conspiracy operating from inside the courtroom. On January 11th, a paralegal, whose identity remains sealed, recorded the conversation that leaked this morning. FBI agents reviewed the audio within hours, but held off on arrests to gather additional evidence. The leak changed everything. Sources indicate prosecutors had planned a controlled disclosure in sealed court proceedings later this week. Instead, someone possibly connected to the same whistleblower networks used by the paralegal pushed the recording into the public domain this morning. Marcus Webb, who founded his law firm 23 years ago and has represented some of the highest-profile white-collar defendants in the country, reportedly sat motionless as marshals approached. Daniel Harriman, a former federal prosecutor himself, who switched to defense work in 2019, allegedly attempted to address Judge Caldwell before being told to remain silent. The third attorney arrested, junior associate Priya Nakamura, appeared visibly shaken. Her involvement in the recorded conspiracy remains unclear, though prosecutors indicated she, quote, possessed knowledge of the scheme and failed to report it as required by law. Smash that like button if this is making sense so far. Every like tells the algorithm this story matters, and it helps push this content to more people who deserve to know the truth. I read every single comment. Drop yours below. The bombshell moment came at 10:47 a.m., and everyone in that courtroom will remember it for the rest of their lives. Judge Caldwell had just received a sealed filing from prosecutors. Court observers describe him reviewing the document for approximately 90 seconds, his face growing visibly darker with each page. Then he looked up. Marshall's, he said one word. The entire courtroom fell silent. For us marshals who had been stationed near the exits, began moving toward the defense table. Webb rose to his feet, beginning to say something, reportedly starting with, "Your Honor, I must object." Judge Caldwell cut him off with a gavel strike so sharp that reporters in the gallery described it as sounding like a gunshot. "Mr. Webb, you will remain silent. You are being placed under arrest. Mr. Harriman, Miss Nakamura, do not move. Do not speak." Harriman's face reportedly drained of color. Nakamura began trembling visibly. Webb attempted once more to speak. Judge Caldwell's response became the moment everyone is now replaying. "Counsel, I have reviewed the evidence of your criminal conspiracy to obstruct justice, tamper with a federal witness, and violate every oath you swore when you became an officer of this court. Your voice is no longer welcome in my courtroom, Marshals. Proceed. Within 3 minutes, all 3 attorneys were in handcuffs. Victor Ashworth, the defendant they were supposed to be protecting, sat alone at the defense table as his entire legal team was walked out in custody. That's when it became clear this isn't just another courtroom scandal. This is the complete collapse of a legal defense through criminal self-destruction. Stay with me. What comes next is even bigger. But first, drop a comment below and tell me, did you see this coming? Have you been following this case? I want to hear from you. I respond to comments all day long. This isn't the first time defense attorneys have faced arrest for courtroom misconduct, but the scale and brazenness of this situation is virtually unprecedented. Think back to the 1990s mob lawyer prosecutions. Several attorneys representing organized crime figures were eventually convicted of acting as house counsel for criminal enterprises, essentially becoming participants in their clients' ongoing crimes rather than legitimate legal representatives. Those cases establish that attorney-client privilege does not protect lawyers who become active co-conspirators. Then there was the 2008 case of prominent Texas defense attorney Stephen Crawford, disbarred and sentenced to 15 years after prosecutors proved he helped his client intimidate witnesses through coded messages during jail visits. That case, however, involved a single attorney acting individually. The key difference now, this appears to be a coordinated effort involving multiple attorneys operating with institutional support. The references on the tape to different teams and structured payments suggest something far more systematic than any previous case. More recently, in 2021, a defense attorney in Florida was removed from a murder trial after evidence emerged that she had contacted a witness's employer. She faced disbarment, not criminal prosecution, because the contact, while improper, didn't cross into explicit criminal threats. The web recording crosses that line repeatedly and explicitly. Former federal judge Richard Howell, who served on the Ninth Circuit for 19 years, told CNN this afternoon, "In my entire career, I never saw anything like this." Defense attorneys threatening witnesses, families, discussing payoff structures, talking about making examples. This isn't aggressive advocacy. This is organized crime wearing a suit. The pattern is clear. When officers of the court become criminals themselves, the consequences destroy not just careers, but entire cases. Now, however, the question becomes, what happens to Victor Ashworth's trial? His entire defense has been arrested. Every strategy, every motion, every cross-examination prepared by Webb's team is now presumptively tainted. The defendant didn't just lose his lawyers. He may have lost any chance at a fair trial. Legal experts are calling this morning's events extraordinary, unprecedented, and potentially case-defining for federal criminal procedure. Professor Rachel Morrison, who teaches legal ethics at Yale Law School, told the New York Times this afternoon that the implications extend far beyond this single case. What we're witnessing is the complete collapse of the attorney-client relationship's protective function. When your own lawyers are the criminals, every privilege, every protection, every strategic conversation becomes potential evidence against you. She added that Ashworth now faces an almost impossible legal situation. Any new attorney who takes this case inherits a poisoned record. How do you prepare a defense when you do and know what your predecessor shared with the prosecution's witnesses? Meanwhile, former U.S. Attorney Jonathan Blackwell, who prosecuted white-collar criminals in the Southern District of New York for 15 years, emphasized the recording significance for potential RICO charges. The references to other teams handling other witnesses suggest this isn't isolated. If prosecutors can establish that Webb's firm operated as part of a broader witness tampering enterprise, everyone who touched those payments, partners, associates, staff, could face conspiracy charges. Criminal defense attorney and legal commentator Victoria Santos added the perspective that many in the defense bar are privately discussing. This is a nightmare for everyone who does this work legitimately. Webb was considered one of the best. 23 years, hundreds of cases, major victories. If he was doing this, what does that say about the pressure corrupting our profession? Santos noted that the fee structures described on the tape is consulting LLCs, offshore entities. Structured retainers designed to obscure payments suggest sophisticated awareness that the activities were criminal. These aren't mistakes. This isn't poor judgment in the heat of the moment. This is a system designed from the start to hide crimes. Even conservative legal commentator William Hardcastle, who has often criticized prosecutorial overreach, admitted on his podcast today that the evidence appears devastating. I've defended aggressive lawyering for 30 years. Aggressive isn't this? Threatening a witness's children's school enrollment isn't advocacy. Discussing how to make examples of other witnesses isn't zealous representation. If this tape is authentic, and the FBI says it is, then these men belong in prison alongside their client. The consensus among experts is nearly unanimous. The tape is authentic. The conduct is criminal. The only remaining questions involve how far the conspiracy extends and how many additional people will face charges. Judge Caldwell's reaction, they agree, was entirely appropriate and arguably overdue. Do me a favor and slam that like button right now. It genuinely helps this video reach more people who need to see it. The algorithm responds to engagement, and every like pushes this story further. Help me get the word out. So what does this actually mean going forward? First, Victor Ashworth's trial is in complete chaos. Judge Caldwell declared a mistrial motion under advisement, but has not ruled. Ashworth's new legal representation, whoever agrees to take this catastrophe, will need weeks, possibly months, to review the case file. Every piece of evidence, every witness interview, every strategic decision made by Webb's team is now suspect. Prosecutors have already indicated they may seek to use the defense team's communications as evidence against Ashworth himself, arguing that attorney-client privilege was forfeited when the attorneys became co-conspirators. If Judge Caldwell agrees, Ashworth faces the unprecedented nightmare of his own lawyer's words being used to convict him. Second, the Department of Justice is expanding its investigation dramatically. Sources familiar with the matter told reporters this afternoon that a task force is being assembled to investigate what the recorded conversation called different teams. FBI agents executed search warrants at Webb's law firm offices in Manhattan at approximately 2:30 p.m. today. Additional warrants are reportedly pending for the firm's satellite offices in Washington, D.C., Miami, and Los Angeles. Every client Webb's firm has represented in the past 5 years may now face scrutiny regarding how their cases were handled. Third, the implications for witness protection protocols are enormous. Witness 14's identity, while still officially sealed, has been compromised. The threats discussed on the tape involving family members, employment, and school enrollment mean this witness and their extended family now require emergency protection. Sources indicate the U.S. Marshal Service has already initiated relocation procedures from multiple individuals connected to Witness 14. If this witness is permanently silenced through fear, harm, or disappearance, the prosecution's case against Ashworth collapses, regardless of what happens to the defense team. Fourth, the legal profession itself faces a reckoning. Bar associations in New York, New Jersey, and the District of Columbia have all announced emergency proceedings regarding Webb, Harriman, and Nakamura, which now appears certain civil liability looms. Every client Webb's firm represented may now have grounds to sue for malpractice. Insurance carriers are already reviewing exposure. Legal industry analysts estimate the firm will be bankrupt within months. The implications for public trust in the legal system are profound. When officers of the court become the criminals, when the people sworn to uphold justice conspire to obstruct it, faith in the entire system erodes. And hanging over everything is a simple, devastating question. How many other defense teams are doing exactly what Webb's team did? How many witnesses have been silenced before they could testify? How many cases have been corrupted by the very people sworn to pursue justice within ethical bounds? Nobody knows. After today, everyone is asking. And then the accused attorneys made it even worse. Within hours of their arrest, statements began emerging from representatives speaking on the defendant's behalf. The approach they chose was telling. Marcus Webb's personal attorney arriving at the federal detention facility told reporters, "This is a politically motivated prosecution designed to interfere with Mr. Webb's effective representation of his client. The recording is being taken completely out of context, and we will vigorously contest its admissibility and authenticity." That claim collapsed almost immediately. When asked about the FBI's voice authentication and metadata analysis, Webb's attorney declined to comment and rushed into the building. Daniel Haraman, a spokesperson, released a written statement calling the situation a grave misunderstanding and claiming Haraman has always conducted himself with the highest ethical standards. The statement did not address any specific content from the recording. Here's the problem with these responses. The tape speaks for itself. When your voice is caught on an authenticated recording discussing threats to a witness's family, payment structures designed to hide your activities, and coordinated efforts to intimidate testimony, claiming context isn't a defense. It's an admission that you said what you said, and now you're desperate. Legal ethics professor Amanda Chen, who reviewed the transcripts, pointed out that the statements themselves may constitute additional problems. Claiming the recording is out of context implies the statements were made but meant something different. That's not how criminal defense of this evidence works. You either dispute authenticity or you explain conduct. Suggesting context while dodging specifics is the worst of both approaches. The defendant, Victor Ashworth, has remained silent. His family issued a brief statement expressing complete confidence in Victor's innocence and declining further comment. While the legal situation clarifies, court observers noted the irony. Ashworth's family is following proper legal crisis management while his own attorneys flailed publicly. Meanwhile, Webb's law firm attempted to distance itself from the arrested partners. A statement from the firm's management committee expressed shock and dismay and announced an immediate internal investigation. 3 named partners have already resigned, according to legal industry sources. Junior associates are reportedly fleeing to rival firms as quickly as they can. When your defense becomes worse than silence, you've already lost the narrative. But beyond the immediate legal firestorm, this is really about something much bigger. This is about whether the American justice system can survive when its own officers become the criminals. Defense attorneys exist to protect the accused. That protection is fundamental to constitutional liberty. Without zealous ethical advocacy, the government's power becomes unchecked.